All right, in this chapter, we're going to look at wrongful convictions in the death penalty. So in the last chapter, we talked a little bit about what exoneration is. And since the death penalty was reinstated in 1976, over 1,200 people have been executed. More than 150 people have been released from death row and 20 from DNA exonerations. Now, keep in mind that exoneration is not necessarily the same thing as innocence. Exoneration is to officially relieve someone of the burden of responsibility, obligation, or punishment. So this is actually referring to legal innocence, not factual innocence. The law purposely puts obstacles in the way of truth-seeking that benefits defendants so we can minimize the possibility of convicting and executing an innocent person. Now, there's a lot of databases that track data on the wrongfully convicted. One is the National Registry of Exonerations, which is part of the U-Michigan Law School. They have information on over 1,550 exonerations. The National Innocence Project has 325 post-conviction DNA exoneration profiles, 25 of whom served time on death row. And more than 75% of exonerations have occurred since 2000. In a 2005 study by Gross and colleagues, they predicted it is plausible for there to be thousands, if not tens of thousands, of other wrongful convictions that we do not know about. Wrongful convictions related to violent crime tend to be the ones that we uncover. So remember that we have two models of the criminal justice system, the due process and the crime control model. Now, the due process model is most critical. The most critical function of the criminal justice system is to protect our civil liberties by providing due process. And due process says how the criminal justice system must proceed. It's basically the rules we have to follow in order to convict and punish someone. And the focus here is on the defendant. The government should not be allowed to convict a person solely on the findings of fact, only if the government follows all the legal procedures as well. And this is often seen as an obstacle course. Whereas the crime control model focuses on repressing crime by prioritizing the swift handling of factually guilty defendants with as few obstacles as possible, and that civil liberties only have real meaning in a safe, well-ordered society. This focuses on the victim and the community and is centered around discovering the truth. It allows for expanding discretionary police powers and limiting legal technicalities that hinder police. In theory, if the police arrest someone, then the accused should be presumed guilty because the fact-finding process by police and prosecutors is thought to be largely reliable. So Blackstone famously said it is better to let 10 guilty persons escape than one innocent suffer. And this ratio was believed to be just and minimize the consequences of wrongful convictions. Now, in 1829, Bentham warned that the sentiment may jeopardize the overall goal of a criminal justice system to seek justice for those who are guilty. Bentham felt that letting a guilty man go free and punishing an innocent man were both great evils. The only more egregious error is the wrongful conviction of a person sentenced to death. So there are 6 big factors that play a role in wrongful convictions. Eyewitness identification is the first one, and it plays a major role in 75% of all DNA exonerations. We tend to believe that an eyewitness is the best evidence we could have, and it's actually amongst the worst evidence. Ronald Cotton was a black 22-year-old man from North Carolina accused of rape and identified by Jennifer Thompson, the victim. He was sentenced to life plus 54 years, and after 10 years was freed because of DNA evidence. He does bear some resemblance to the actual offender, and there's a great book about this called Picking Cotton, and Thompson and Cotton became friends afterwards. So it's important to remember that victims and witnesses are not always reliable when it comes to recalling specific details about their attackers. This is especially concerning when it's the primary evidence. So Troy Davis was executed in 2011 in Georgia for murdering a police officer, and his conviction was based on eyewitness testimony. Now, the murder took place in a crowded Burger King parking lot with 34 witnesses. 7 of the 9 witnesses who testified it was Davis later recanted their stories. So we know that memory is very malleable and it's highly unreliable, and there's almost nothing more convincing to a jury than eyewitness testimony, despite the fact that it's very unreliable. Now, there's 4 general reasons for eyewitness error. One could be straight up lying. The person's perception may be inaccurate, their memory may be inaccurate, or their recollection could have been influenced by some outside suggestion. System variables, those that are linked to the investigative phase and its impact on witness memory. These would include things like improper lineups and suggestive interview techniques. And estimator variables, which occur outside of the investigative process, having to do with things that might impact your observations. So this could be lighting, how close you were to the crime, the weather. Wording used during lineups can play a role in misidentification. You may be told to choose the person who most resembled your attacker, or police may tell you you selected the wrong or right suspect. We should always use double-blind lineups where the officer doing the lineup does not know who the suspect is. And it's important to use best practices when collecting eyewitness testimony. We have to retrieve and preserve it carefully so as not to contaminate it. We should inform witnesses that the suspect may or may not be in the lineup. Sequential lineups are much more effective, where you show somebody one person at a time. The filler should closely resemble the suspect, and we should ask witnesses to identify their degree of certainty in their identification. Other efforts have focused on legislative remedies. It's not uncommon for courts to uphold convictions even on botched lineups and questionable eyewitness testimony. 2009, Maryland required prosecutors to have DNA evidence linking the defendant to the crime, a recorded confession of the suspect, or a video of the crime in order to seek the death penalty. In 2012, New Jersey required judges to provide jury instructions on the reliability of eyewitness testimony. The jury should be fully informed when making decisions about how credible a particular eyewitness is. The second issue is false confessions. These are relatively normal and they're brought on by unusual circumstances. They occur in about 27% of DNA exoneration cases. Confessions are universally treated as damning and compelling evidence. And there are three types of false confessions. One is voluntary. This is someone who wants to, take the rap for someone else, or someone who has a pathological desire to seek attention. And these confessions are provided without any prompting by the police. Compliant confessions are prompted by highly stressful police interrogations. They're seeking short-term relief by confessing so they can be removed from the stressful situation. And this is often a result of the read technique, which is an intensive interrogation tactic that often includes intimidating a witness by providing false information. So the detective or the officer who is interrogating the defendant, suspect, may minimize the seriousness of the crime and the consequences, or the interrogator may pretend that they can identify with and want to help the suspect. And then our third type is internalized, where the person becomes convinced they actually committed the crime, and these generally follow highly suggestive police interrogations. Casson identifies three significant problems with confession evidence. One is that police are unable to tell the difference between those who tell the truth and those who lie. Some interrogation practices put innocent people at risk for confessing, especially those that are vulnerable. And both judges and juries tend to trust confessions even when clear evidence suggests that a confession has been coerced. And little has been done to combat this, and this is largely because the police are poorly trained in interrogation techniques. Leo and Offshee in 1998 recommend recording all police interrogations, but only 18 states currently require this. One of our other main errors here is informant testimony. This is the first documented case of a wrongful conviction using informant testimony was in 1819. The snitch was placed in a cell with the suspect and claimed that the brother confessed to a murder. This led to the conviction and death sentence of both brothers. They were freed when it was discovered that the murder victim wasn't even dead. So informant testimony is a key issue in more than 15% of DNA exonerations. This is incentivized testimony. It's inherently flawed because there's some motivation, something that the informant is gaining. They generally receive a deal for their cooperation, and not all states require the prosecution to disclose this at trial. Leslie Vernon White was a notorious snitch who repeatedly duped the LAPD and fabricated testimony in at least a dozen cases. He would ask cellmates about their cases, then call the courthouse from the jail, posing as law enforcement or the prosecutor, to obtain details not known to the public. Then he would claim that the defendants told him this information. So we need to have better procedural safeguards in place for informant testimony. We need to wire them so their conversations with suspects are recorded, record exchanges with law enforcement when they meet with informants, and require prosecutors to disclose any compensation. Bad science. More than 50% of DNA exonerations are a result of bad science. We know that a lot of forensic science is not valid. Fingerprints haven't actually been validated. Hair comparison, arson analysis. So fingerprinting lacks adequate testing and standards. Computer matching requires good prints, and when they are partial or smudged, techs begin by examining them by comparing ridge characteristics. There are few standards for matching, and this is more art than science. Hair comparison and analysis, if the root is attached, we can generally get DNA. But other types of hair analysis are the weakest of all forensic lab techniques used, with error rates as high as 67%. Well, what can we do to fix bad science? We can train police departments on practices that minimize error, train defense attorneys and prosecutors, and provide statistics and expert testimony. It's important to remember that DNA testing is expensive and not always available. New York City uses it in only 7% of its murder investigations. And DNA testing isn't an option in less than 10% of serious felony cases because there is no testable evidence. Ineffective defense of counsel. Your Sixth Amendment provides you a right to counsel, and that means effective assistance of counsel. About 80% of criminal defendants require a court-appointed counsel. In the largest 100 counties, public defenders handle 82% of all criminal cases, and in death penalty cases, it's 90%. Now, appointed counsel are significantly more disadvantaged. Those who hire counsel are significantly less likely to be sentenced to death. So being assigned inadequate counsel largely depends on the level of training and resources provided to counsel by the state in which the attorney is employed. The Strickland standard is how courts determine if counsel was ineffective. So first you have to prove that your counsel's performance was deficient, and then the error also has to be prejudicial. Has to result in an unfair trial, but for the errors of the attorney, the trial outcome would have been different. So this is kind of ambiguous, and courts generally only grant trials for those who might obtain a different outcome. Examples of this could include failure to investigate an alibi, failure to be present at important court hearings, and government misconduct. So sometimes the prosecutors and police engage in misconduct. Sometimes it's a mistake. Sometimes the person is so intent on securing a conviction they lose sight of other duties. And this is connected back to those other big six causes. Now, a special investigation in Chicago found a police commander who was instrumental in cover-ups of other cases. He was convicted in 2010 of perjury and obstruction of justice and is serving a 4-year prison sentence. And Chicago paid over $56 million in settlement fees. The decision to move forward with charges lies with the prosecutor, and they have the most power in the system. In a study of 88 post-Furman exonerations, 31% involved prosecutorial misconduct, and about half were for withholding exculpatory evidence. So that's evidence that's favorable to the accused that might exclude them as a suspect. Now, under Brady v. Maryland, this is supposed to be presented to the defense by the prosecutor. Other cases involve perjury and improper use of evidence. Now, in a report on Illinois death penalty cases, 21% of reversed cases were reversed because of prosecutorial misconduct. And in Ohio cases, 14% or 48 cases involved ethical violations by prosecutors. Prosecutors are rarely held accountable when they engage in unethical behavior. In a study of 381 murder convictions that were reversed due to police or prosecutorial misconduct, not a single prosecutor was held criminally responsible or disbarred. So prosecutors have two types of immunity, absolute and qualified. Absolute immunity is when acting as an advocate, they are granted complete immunity, even if there's proof they acted intentionally, in bad faith, and with malice. And many people feel that this type of immunity should be reconsidered. Now, qualified immunity applies when acting in investigative or administrative roles and your actions clearly violate the law. They may not be immune. Now, exonerees are not immune from significant disadvantage. Some states, like Idaho, don't provide any compensation. 27 states, DC, and the federal government do have statutes for compensations, and it's generally based on the amount of time served. Few provide extra compensation for time spent on death row. So the federal government pays $50,000 per year and another $50,000 per year for time spent on death row. Exonerees are at great risk for offending post-release. A study of 118 exonerees found that those who were awarded more than $500,000 offended at a significantly lower rate or not at all. So remember that they're often starting over and lack job skills, and so that compensation is critical to their successful reintegration into society.